Meeting to order. I will conduct the election of chairman. Members, nominations. Ms. Darili, I nominate you yourself, Mr. Chen Kam-lam. Any seconders? No? Okay. Sin Chung Kai, I nominate Mr. Kenneth Leung. Any seconders? Any seconders? We have no seconders. Let's wait for a bit more.
我哋7個人就夠㗎啦。好啦，我哋再嚟。
Let's start again. Members, Ms. Darili, I nominate Mr. Chen Kam-lam. Any seconders? Seconded by Mr. Chong Wah-fung. Any other nominations? Sin Chung Kai? I nominate Mr. Kenneth Leung. Any seconders? No seconders. I am a candidate. I accept the nomination. What do we do now? Well, I am elected ipso facto because there is no seconder for the other nomination. Thank you. Do we need a deputy chairman? No. We all think it's not necessary. Let's invite the administration to come in.
Declaration
of interest. Members, please. Ms. Darili, my company may engage in consultation related to inland revenue, but I myself is not a part of it. Mr. Kenneth Leung, I engage in tax consultation, and so is my company. Mr. Chong Wah-fung, we may participate in the sale and purchase of bonds. Well, then you make a declaration. If there is a chance that you engage in bond transactions, well, it's not your personal interest. But if you are a practitioner, well, if it's listed in the exchange house, then I will somehow relate to it. So there is a possibility that it may be related to your work and your interest, and that's so declared. Let's welcome the administration. We have with us Ms. Selina Yan, Deputy Secretary for Financial Services and the Treasury, Mr. Jackie Liu, Principal Assistant Secretary for FST, Ms. Wong Kun-fai, Deputy Commissioner of the Inland Revenue Department, Ms. Betty Cheung, Senior Assistant Law Draftsman from the DOJ, and Mr. Darrell Ho, Head Market Development Division, Hong Kong MA, Ms. Carrie Chan, Senior Manager, Hong Kong MA, Mr. Alan Ng, Senior Assessor, IRD, and Mr. Manuel Ng, Government Counsel, Department of Justice. Ms. Yan, this is the Inland Revenue and Stamp Duty Legislation Alternative Bond Schemes Amendment Bill 2012. This is to facilitate the development of Islamic finance and Islamic bond. This is to remove the impediment the impediment that was in Islamic bonds, but not in conventional bonds. I have prepared a presentation, and I will defer to Mr. Liu to give you the presentation. Thank you. We have prepared a PowerPoint presentation for members. It's been tabled in front of members, and I will make use of the PowerPoint presentation and the electrical brief as my skeleton. First, about Islamic finance. Members have spoken that, and in the fact that they may know something about this, but I would like to say that for Islamic finance is one of the fastest growing segment in the international financial system, and that is not limited to Muslim countries and Muslim investors. There is a global trend to develop Islamic finance to diversify the financial market. Last year, we saw that there has been over 14.5 trillion of market capitalization in relation to Islamic market, or because of rising oil prices, and there is accumulation of great wealth in Middle East countries. Investors inclined towards investing in emerging markets and stable financial products, and to diversify the market. All these reasons explain the fast growth of Islamic finance. We have a mature and developed platform, and we think that there is a chance for Hong Kong to develop a diversification of financial products, including Islamic financial products, to meet the needs of investors. This will be conducive to our competitiveness, and it will also consolidate our position as the international financial market. In the past few years, when we're drafting different bills, practitioners from the banking, from the legal sector, and from the accounting sector reflected to us that Hong Kong has the condition to develop this business. So the administration considered the legislation introducing amendments to be so that it will facilitate the development of such products. This is different from conventional bonds because that was based on liability, and the issuer will have to pay coupon payment to holders. It's rather simple. Under the stamp duty ordinance, there are provisions dealing with tax reliefs or special tax treatments. But the Islamic bonds is different from conventional bonds because under Sharia law, there is a prohibition on the payment and receipt of interest. So when it comes to Islamic financial institutions or originators or issuers, they will have to launch more complex products to meet the Sharia law requirements, and there are limitations in the market. When it comes to Islamic financial market, they will make use of multiple assets, say for example buying back, leasing, restructuring to generate proceeds as a payment to investors and bondholders as a return. The structure between Islamic bonds and conventional bonds are different. The current IRO and the SDO cannot cater for the former. And even when it comes to tax treatment and tax relief, currently they do not apply to Islamic bonds. Market practitioners have reflected to us that this will impede. This will put Islamic bond issuers in a disadvantageous position. The purpose of this bill, well, it amounts to 200 pages to amend the IRO and the SDO. This is to accord a similar framework to Islamic bonds and to take away the impediment of the development of Islamic bonds in Hong Kong. I'd like to reiterate that we will not accord special or more favorable treatment or tax relief than conventional bonds. If, well, all the treatments for conventional bonds will apply to Islamic bonds to ensure that similar tax treatments will be offered to financing of Islamic bond. We will adopt a religion-neutral approach. We set out to facilitate development of Islamic finance, but we have not made reference to any terminologies in Sharia. This is in line with our approach of religion-neutral approach, and we have spent a lot of coverage on the description of the Islamic financial products, and there are a number of provisions in place to form the tax framework. There are some empowering provisions empowering the FS by way of subsidiary legislation to include different types of Islamic bonds and to amend the special characteristics of such bonds to meet the changing market. Page 6. This is an illustration for members.
In this amendment bill, as we said, we are religion neutral. We would not call these financial products Islamic bonds. We would call them as alternate bond schemes. There are two parts to such a scheme. One is investment arrangement, and then the second is bond arrangement. The originator is the one who wants to issue bonds, and he would establish a special purpose vehicle, and in this amendment bill we would call it a bond issuer. And then they would engage in some activities to generate returns for the investors. Now, for these investment and business activities, we would say that this is investment arrangement, and on page 6 is in the yellow box. This is investment arrangement, and the bond issuer for raising capital will issue some coupons to the bond holders or the general investors. And in this relationship, under the bill, we will call it a bond arrangement. So the amendment bill and describing the alternative bond scheme will divide it into two parts. One is investment arrangement, and the second part, bond arrangement. For Sukuk, it is a brand new financing tool. Some members may be aware that the product structure is rather complicated. It's not possible for us to cover each and every Islamic product in the market. So we've selected five most common types of Sukuk. According to market analysts, over 90% of the products fall under these five types. Ijara, lease arrangement; Murabara, profit sharing arrangement; Murababa, purchase and sale arrangement; and Wakala, agency arrangements. In our amendment bill, we are not using these Islamic terms, but then we use some detailed description to describe these financial products. The bond issuer has to meet with these characteristics before they are entitled to the tax treatment. You said there are 5 types, but then you mentioned only 4. Well, but then in the profit-sharing arrangement, there are actually 2 subdivisions, musharaka and mudaraba. So in introducing the amendment bill, I can give you a further or detailed discussion of the structure of each type of product. Let me cite a rather simple example of lease arrangement in JARA and to explain why such an arrangement will involve extra tax liabilities. On page 7, you can see that the yellow part is the investment arrangement. The blue box is bond arrangement. Usually, the originator is the one who needs the funds. And as I said, they would establish a special purpose vehicles, the bond issuer, which issues the bonds. And then it will serve as an intermediary and issue alternative bonds as a sukuk. And then the bondholders will give them the bond proceeds. And then the bond issuer will immediately acquire some assets. The seller is usually the originator, or the bond issuer may arrange for a third party to be the seller to generate returns. The bond issuer, after acquiring the asset, will also lease out the asset or release it to the originator to generate funds to generate coupon payments for the bondholders. And actually, it is similar to the interest payment for conventional bonds. And they are doing it in a sort of a profit-sharing approach and to share it with the bondholders. It's a likely principle of a share pay share gain and under Sharia law. Upon the expiry of the bond, the bond issuer will resell the bondholders will sell the bond issuer, and then the redemption payment will be paid to the bondholders. Under this lease arrangement, according to existing tax regulations, there will be a lot of transactions, including the acquisition of assets, leasing the assets, and reselling the assets to the originator. All these involve transactions. If they involve immovable assets under the existing law, they will have to pay for stamp duty charges. And also, the bond issuer gives the proceeds to the bondholders will be deemed as profits, and then the bond issuer is subject to property tax or profit tax. Now, under IRO 14A and 2014, the tax exceptions provided therein will not be applicable to the sukuk. Because sukuk raise funds as like conventional bonds, and because they involve complicated structures like special purpose vehicles and multiple asset transfers to meet with the Sharia requirement. So we must give exemption to such taxes so that we can provide a level playing field for sukuk. I've talked about a typical lease arrangement, but under the amendment bill, we've got description on this kind of lease arrangement. There are 3 other types of arrangement. I will not go into the details of those, but if we scrutinize the bill, I'll be very happy to provide more information on the legal intent. Now, second part of the amendment bill, after handling the structure, we have come up with some qualifying conditions to ensure that those who will enjoy the tax treatment really meet our targeted products. We will ensure that the ABS is economically equivalent to a typical convention bond structure, and only by that way they will be entitled to the same treatment as conventional bonds. As another amendment bill, we would have to put in place to minimize tax avoidance. As I said in the beginning, we hope to, through this amendment, promote the development of this market. So the sukuks should be related to Hong Kong and can directly promote Hong Kong's financial industry's development. So in page 9, when we draw up the qualifying conditions, we have taken into account the legal intent. So these conditions or qualifying conditions are must meet with a reasonable commercial return condition, and in the financial reports they should be regarded as financial liability. We also have this condition that these ABS maximum term length is 15 years, and also they are related to Hong Kong. They're either issued in Hong Kong or listed on the stock exchange, or they are lodged with and cleared by the Central Money Makers Markets Unit of HKMA, and they should also be sold or marketed in Hong Kong to satisfy this particular condition. In the bills committee, if we are to scrutinize the bill, then I can provide you with further information on the rationale of coming up with such qualifying conditions. So so much for the second part on qualifying conditions. So the market is very concerned. Now, if the qualifying conditions are met and their products come under the definition of sukuk in the amendment bill, so what are the tax treatments offered to them? So a third part of the amendment bill will take care of the tax treatments. The overall principle is that in conventional bonds, under the IRO and SDO, the debt arrangements therein will be applicable to the sukuks as well. So according to 14.8 and 26A of IRO, the tax exemption therein will also be applied to ABS. And Section 16.2F of IRO can allow for deduction of the interest of conventional bonds, and that clause is also applicable to the coupon payment of ABS. Now, under IRO Section 20AC, non-residents in the interest received in conventional bonds are exempt from profits tax. So this should also be applicable to the interest generated from ABS. Now, under the SDO, transaction of conventional bonds are exempt from stamp duty. I think in the future, ABS should also be able to be entitled to that exemption. Now, on page 11, on the investment arrangement, the bond issuer or the originator, the transaction, as I mentioned in Ijara arrangement, there are actually multiple transfers of assets between the originator and the bond issuer, leasing, transactions, and so on. So these relations actually established or made solely for the purpose of issuing the bonds. So we suggest that all these, the acquisitions, leasing, and disposal between the originator and the bond issuer should be exempt from the profits tax, and also the stamp duty and the property tax will also be exempted. The transfer of instruments executed in relation to those transactions will also be exempted from stamp duty under SDO. Looking at these applications, the Inland Revenue Commissioner will make sure that the arrangements are similar to those conventional bonds. If the conditions are contravened, then they will be disqualified. If their qualifications have been lost, the Inland Revenue Commissioner will withdraw the tax treatment, as if these tax treatment has never been granted, and the tax due will be collected, and that applies to investment arrangement and bond arrangement. And also in the amendment bill, there are also provisions on record keeping, notifications, assessments, and other miscellaneous matters, and also the period where the stamp duty is to be paid. That all these will come under the tax framework that we are going to propose. The drafting of the amendment bill has been going on for some time to ensure that the bill will really help the investors and the financial institutions which engage in such ABS. So in last March and May, we conducted a public consultation. We've received a total of 15 submissions. The majority of them are in support of the legislative proposal, and the government is thankful for the support and also the opinions submitted by various parties. So when we come up with the draft of the amendment bill, we have taken on board many of their opinions. So at the end of October, we have compiled a consultation conclusion, and actually at the end of last year, we issued a document to the LegCo and said that we would bring the legislative proposal for scrutiny by the LegCo. And in November last year, in the panel on financial affairs, we also reported on the legislative proposal. So much for my presentation today. So when the Bills Committee scrutinizes the bill, I and my team and our colleagues are ready to answer questions raised by members. Thank you very much. Members, questions? Mrs. Darley. Well, thank you for your presentation. Well, pardon me for asking some questions which you may consider very basic. Characteristics of Islamic bonds. You said that the Sharia prohibition, there is this prohibition on interest, and that the creation of a purely debt-based saleable security is not possible. And you also said that under Sharia law, there is a certain regulations on financial products. I really don't quite follow. Can you explain more? What is the attractiveness of this kind of sukuk? Do Muslims only buy Islamic bonds and not other types of bonds?
Ms. Chen, thank you. Yes, in answer to your question, our understanding is that under the Sharia, you can't get interest by paying out an amount of money or make use of the simple concept of offering a loan, or used a simple financial transaction to generate a revenue and to get interest. That means interest generated from a loan is prohibited under the Sharia law. Is that right? That's why you cannot have a bond arrangement. That's right. Basically, yes. That's why there needs to be some business undertaking, some kind of financial activities before it is allowed. So Muslims will only buy Islamic bonds. Is that right? That is the practice under their religion. And it's different. There may be a different arrangement in a different religion. We're not going to comment on that. From our observation, the target group of Islamic bond is not limited to Muslim communities. So such vehicles or financial product or investment products, the target group is not necessarily Muslim communities. General investors are more and more interested in this type of product. We observe in the market that investors, when choosing an investment product, will look at the return. Sometimes they may think that there are something special about such product. There is booming economic development in the Muslim world, and there is a great demand for investments, and their economies support such markets. So there are appeals of this type of product. Some investors, particularly those in US and Europe, will see that the conventional bonds or treasury bonds are more risky, and this will provide an alternative. And they keep an open mind and are not interested in this type of product. For Muslim countries or Muslim economies, their economies are developing very fast, and there is a need for financing. So there is such need for originators. Let's see if the Hong Kong MA has anything to supplement when it comes to the appeal or the market development. And afterwards, I may supplement about the unique appeal of using Hong Kong as a platform. Mr. Kwok. Mr. Ho. Why some people will specifically have to buy Islamic bond in the Muslim world under Sharia. When it comes to an investment conduct, they have to meet certain requirements. Say, for example, they should not charge an interest, and there should be some real economic effect. But is it the case for in general? Not necessarily. There are more and more investors who would like to make investments that are Sharia compliant. So we have an increasing demand. And in some Muslim countries, the legal system is one that is based on the Sharia law. The banking system will put in place a Sharia requirements and provide Muslim banking services. Banks receive deposits, and they may need to make arrangements or make use of the fund, and they have to make sure that the investment of such funds will be Sharia compliant. Say, for example, in Malaysia, there is a huge Muslim banking system. Idling funds will be put in Islamic bond. In reply to Ms. Lee's question, well, the first type is individual investors. Say, for example, royalties of oil countries. They incline towards investing in instruments such as Islamic bonds. And countries with Islamic banking system, there is a growing need for investment of Islamic bond. Mr. Sin Chung Kai, another silly question. Well, this piece of legislation is target Islamic bond. You call it alternative bond scheme. So it's neither fish nor flesh. People who know about Islamic bond, they won't read the terminologies because you won't make references of them. But when it comes to conventional bond investors, they don't know what this is all about. So for those interested in Islamic bonds, they don't see friendly terminologies or the jargons they are familiar with. Mr. Alter.Bond said that they won't buy. Don't buy anything you don't know, and only buy things that you know. So if they see words like mushakara, then they will buy it. But you won't find such terms in the legislation because you've set down a policy to be religion neutral. And you've tailor-made this. Then why don't you do it the whole way? Instead of having this religion-neutral approach. I don't know the consequence. I don't know about what you find in the consultation. I don't think you have targeted it to the right group. People who don't know about this type of product, they will not go near it. And for those who are familiar, they won't find words that they are familiar with. Ms. Yan, we draft this with using a religion-neutral approach. That itself is correct, and Hong Kong is not the only place who has adopted this approach. In other jurisdictions, say for example in the UK, they have adopted a similar approach. Market practitioners or market participants will know. Yes, there may not be explicit references to certain religious terminologies, but this is not something novel. We have conducted a consultation. In general, the market accepts this approach of descriptive or prescriptive one when it comes to the description of the product. Islamic bond is a general term. There may be different structures with different descriptions. At least five products is covered in this legislation, and we don't rule out the possibility of adding more. So even if we name the Islamic bond, we have to give a description to enable the Commissioner of Inland Revenue to take action. This is unavoidable. Of course, when it comes to drafting, it has increased the complexity and technical level. And in the consultation process, we consulted on the concept and on the various technical points. We have given quite a lot, there's some descriptions of what we are going to do when we consult the public. So it's not just consultation on the idea itself. We don't see big problems. We think that it's operable in the market and is appropriate. And from the perspective of an investor, I agree with legislators that that one has to be careful with products that one is not familiar with. And of course, you have to be familiar with the investment product. You have to know quite well about it indeed. We'll cooperate with the Hong Kong MA to conduct some fora or some education activities. Mr. Sin Chung Kai, a follow-up question. Well, in 2010, 2012, you've been to the Legis, as I've read from the background brief. Of course, you have done consultation, but we've learned a lesson from the company's ordinance. What can you tell this committee? This is different from company search. The IRO is to provide convenience for people, because without such convenience they won't be able to carry on their business, and the result will be the inability to make a profit. So you put in place a new framework for new businesses. Without this framework, there won't be any new business. And you mentioned the UK. Perhaps I did not read the information paper carefully enough. Can you give me more information about other common law jurisdiction? What is the mainstream approach? Is it religion neutral? What is the approach of the US? And what about Australia and Canada? In reply to your first question, our consultation is very open, and you'll find relevant information on the internet. It was quite specific. We have set out specific details of how we propose to draft the bill. Prospective market participants will know about the operation. If I understand correctly, members' concern is that the bill introduced may not be operable, and it may not achieve our goal to facilitate the development of the market. That is also our concern. And that's why we have, in relation to specific provisions and the general mode or style of drafting, we have set them out. And we have received very specific feedback. Say, for example, and we have taken on board comments in certain areas. What we have taken on board are the 5 types of Islamic bonds. When we drafted for the consultation, there were only 4, and we have added wakala after the consultation.
This is a specific point that we have taken on board from the public consultation. If they don't find the way what we're proposing is infeasible, then they would certainly reflect their views to us. And also, other requests, like the record-keeping requirement, we have shortened the period required. And also, wakala, in the consultation, we believed that the period should not be too long. We proposed 10 years, and after public consultation, and people told us that as products develop over time, so can that be lengthened? So we've extended it to 15 years. So I think specific suggestions have been received from the consultation. At the Bills Committee stage, of course, we are more than happy to listen to your further views. And later on, we can also share with you our consultation document and the consultation conclusion. Mr. Liu, I can supplement on the jurisdictions in as far as tax laws are concerned. We observed that in places like Malaysia, the UK, Singapore, Japan, and France, in these jurisdictions, they have amended their tax laws to provide the necessary clarity and to provide a level playing field for conventional bonds and Islamic bonds to further development of Islamic bonds. Their tax framework may not be exactly the same as Hong Kong's, so it would not be possible for us to make a direct comparison. But we did observe that the 5 most common types of Islamic products covered under the amendment bill are sort of covered under the tax reforms worldwide, say in Singapore, Malaysia, and the UK. they have just covered the one type of arrangement, and we are now taking a very comprehensive approach. Malaysia is also taking a very comprehensive approach. So all Sharia compliant transactions are entitled to tax exemption and stamp duty exemption. So I also observed that for some accountancy firms, they have done studies on the tax reforms in different legal jurisdictions. If members are interested, we can share those the information with you. I'm not following up, but I would just want to make this comment that I think the subcommittee should invite the public to give their views as a follow-up measure. Mr. Kenneth Leung. Thank you, Chairman. Can the administration give us some figures? For the 2 years of 2011 and 2012, how much Hong Kong sukuks have been issued? That's the first piece of information. And the number of bonds which have been exempted from tax and stamp duty before the amendment, the legislation is to be put in place. Actually, they can ask for discretion from the Inland Revenue Commissioner and the stamp duty collector for exemption. That's the second piece of information. The third piece of information, maybe the HKMA colleagues can help. I want to know how many banks have Islamic windows or Islamic desk. I'm sure that the HKMA has such information. So this is the information that I would want to know about. Second point is about the ABS, the structure. In the amendment bill, you use religion-neutral terminology. Is it true that there is a dedicated section in the amendment bill to describe how the assets in each product will be transferred? But then I'm worried that no matter is Euribor, it seems that you have a detailed description in your draft legislation, but let's not forget that under Islamic law, some types of commercial activities are prohibited. Say, if you use the assets for gambling or to, say, produce canned pork, and that is not covered in the amendment bill. Now, you've made detailed descriptions on the structure of the products, but there are these cases that I mentioned. Have you considered how you're going to tackle the matters that I raised? Thank you, Mr. Leung, for your question about the information you requested. At present, Islamic bonds issuing activities are on two levels. One is listed on the Hong Kong Stock Exchange. In the past 6 years, there are 6 types of Islamic bonds which have been listed on the stock exchange, involving $5.8 billion. And the originators are, say, the Malaysian shareholding investment companies, and their period is from 5 to 10 years. So that's the first point. From market insiders and accountancy firms, we know that some enterprises have also, through private placements, issued Islamic bonds. There is no official record of such types of activity, so I can't provide you with very specific figures. Can I follow up with one question? Private placements, there is no official record. Is it true that because they are sold to institutional investors, so that's why the HKM doesn't have such information. Yes, that's right. Second question, in the past few years, under the IRO and SDO, other administrative measures or exemptions granted under our administrative arrangement. IRD colleagues, please. Under SDO, IRO, there is an exemption mechanism. The CE in council under IRO can grant such exemption. We have so far entered one case. We won't give you the name. Is it successful, the case? Well, sorry, because of privacy concerns, we're not going to give you the tell you that. And also SDO, there is a similar exemption. We also have handled one case, and one other case is being processed. About if the sale of products which contravened Islamic laws. Okay, well, I'll tackle the first question about Islamic banking activities. Among Hong Kong banks in Hong Kong, there is one Malaysian funded bank called Fong Long Bank. In 2008, it established an Islamic deposit service, and they provide Islamic products to their customers. The HKM has also processed a Maybank from a Malaysian bank for setting up an Islamic banking window in Hong Kong. So these are the two banks which are engaging in Islamic banking activities in Hong Kong. Mr. Kenneth Leung also mentioned about the Islamic law making certain prohibitions on commercial activities, say like gambling or transactions of pork. We understand that under the amendment bill, because we use a religion-neutral approach, and the amendment bill is really focusing on tax treatment, hoping to extend the treatment granted to conventional bonds to Islamic bonds. So in describing the Islamic products, their characteristics, we would not list out each and every one of the characteristics of Islamic bonds, because these characteristics are not very much related to tax treatment, and we don't want to handle them specially, and we don't want to over-restrain such activities, the flexibility of carrying out such activities. So, Mr. Kenneth Leung, you mentioned about these characteristics. The bond issuers, I'm sure that they will pay attention to what you mentioned, because they want to ensure that their transactions are complying with the Islamic laws. But this is something not of concern to the amendment bill on hand. I just want to follow up on Mr. Sin Chung Kai's question. You've adopted this new religion-neutral approach. The market and the investors are not very clear about ABS, and that it is equivalent to Islamic bonds, because you haven't made any mention of activities that I mentioned. Well, even if such a scheme is put in place, it will attract no customers, and people will not be aware that we have provided a very good platform for them to engage in trading of Islamic bonds. Now, Islamic financial products are developing at a fast pace, so I would also like to invite industry players to give views here. Mrs. Starry Lee, I also want to raise some questions which are basic, because this is a novel thing to me. In your paper to us, you said that Islamic finance is the fastest growing segment in the international financial system. Do you have any information to show why it is so attractive, why it is the fastest growing segment? That's my first question. My second question is, in Hong Kong, if we want to amend the legislation, we want to drive the development of Islamic finance in Hong Kong. I think this is an appropriate thing. This is good. And so what the members suggested should be considered. If we term it as alternate bond scheme, it might not be able to achieve what we intended to do. Of course, we will be very open-minded and we will listen to what the industry has to say to us. What we want to do is to attract people or attract investors to join the market. If we can term it as Islamic bonds, and that might be able to achieve that purpose. Now, my third question, if someone wants to sell Islamic bonds after the bill is passed, does it have to go through the SFC and the HKMA? What about the selling points? Are they limited to banks? And also those who can participate as investors, would you be making some distinctions on the category of investors to be allowed into the market? Because of the Lehman Brothers incidents, we are quite worried on that point. Thank you, Chairman. Thank you, Ms. Lee, for your question. 3 points. Why is it that the Islamic bonds or Islamic finance is developing so fast? We've touched upon that just now. The Islamic economy is developing by leaps and bounds in recent years, and they have advantaged in their natural resources, and because they have this financing need, so there is a great demand for Islamic products. On the buy side, there is also this demand towards there is a rising demand for products from emerging markets, and the risk of these markets is not that high as compared to other European US markets, because these are the latter markets are more risky sometimes. So by comparison, these products are quite attractive, and they are registering phenomenal growth. In Hong Kong, Hong Kong should be a part of the Islamic. We are not part of the Islamic economy, but then Hong Kong is very attractive as a financial center. We attract players from different parts of the world. The investment scale and the liquidity is big and high, respectively, and we attract investors to use Hong Kong as a platform to raise funds and invest. And the same goes to issuance of bonds and investment. And in recent years, because our economy is tied to the development of RMB, in recent years there are some Islamic bonds which are renminbi denominated. So Hong Kong is very unique in that aspect. We have unique advantages. So that's why we are so keen that we have to put in place a legal framework and the infrastructure to attract investors in that sector.
Okay. Mr. Leung asked in the past how many cases have applied for exemptions. The number may be low, but it shows that some investors or issuers, because of the lack of facilitation measures in Hong Kong, chose to go elsewhere. We have been told this. So we need a legislative framework to facilitate the development of this market. Of course, in the end, whether people will choose Hong Kong to develop or to issue the product is the choice of the market. And when it comes to where the point of sales of investors, for this alternative bond schemes, like conventional bonds, it is an investment on of bonds. So sell and purchase, a transaction is subject to statutory requirements or the law under the SFCO. Under the SFO, they have to conform to codes. They have to be responsible for explaining the details to investors, just like any other investment product. If there is issuance or offer made to the public, the offer document should be vetted by the SFC, and some disclosure requirements will have to be met, or disclosure requirements will have to be met. And that is the same as any other investment products. It's not that they've been given a more lax approach. And as I've said, investors have the responsibility to know about the product. And this is not a product that will come across day to day, and we see the need to publicize it. I'd like to follow up. Ms. Yan, the DS, said to us that this will follow a general investment product. I stand to be corrected. They may be called bond, but there is an apparent part missing because there is no interest. And there will be some special vehicles and the investment structure and different ways of profit sharing. We're talking about a complicated product. How will you let consumers know? Because to the market, this is a new product. So how is it reflected that the purchase price is $1 and at maturity you'll be given $1.20? I will defer to the colleagues of the Hong Kong MA, but there are arrangements when it comes to coupon payment. In other words, a return. The main target group of such product in Hong Kong is institutional investors. They are quite familiar with this product, and when it comes to making it more popular to reach out to the general public, yes, they need to know more about the product. I will defer to the Hong Kong MA. Mr. Ho. I thank Ms. Lee for her question. I'd like to emphasize that the majority of financial Islamic bond is that there is a reality that they are in effect bonds. The originators gives an undertaking to return the capital, and coupon payments will be made in accordance with the agreement. Because of religious reasons, they cannot explicitly offer a loan and charge an interest. So in the issuance of Islamic bond, different structures will be put in place to turn interest payment and the offer of a loan into something that is Sharia compliant. The complicated structure is that because they have to ensure that what they're doing is Sharia compliant, but for an investor, it is in essence a bond. And as a number of members mentioned, were asked why we did not call it outright Islamic bond. Well, we have to look at the target group of the bill. The objective of the bill is to clarify the tax environment. If we are to issue Islamic bond, and when you put in place the structure, you will get these tax treatment. The target group of the legislation are investment banks or the issuing sections of such banks. They package the bond. And you may wonder how people will know that they are buying Islamic bond and not alternative bond. When an investor comes into contact with an Islamic bond, they will know about the bond based on the prospectus, and it will be made clear that it's an Islamic bond, and it will set out the structure, musaraka or ijara. Say, for example, and in the prospectus, based on what a tax environment or legal environment is the package, and if it is in Hong Kong, then it will be the one that conforms to the Hong Kong requirements. For an investor, we think that is clear because the main information paper for them is the prospectus. And when it comes to professional sectors, say for example investment banks or bond issuance sections, they are quite familiar with what they can do and what they have to do. Is it clear? I have a question about the qualifying conditions. Once a product is disqualified, then it's treated as if it has never been qualified. But investors have already purchased the bond, and halfway through the qualification is revoked. How can you ensure the investors can get back the money? When it comes to the qualifying condition, we're talking about the tax, those in relation to tax treatment, and is separated from the product itself. They're two different matters. We aim to offer tax relief offered to conventional bonds to Islamic bonds. We're talking about disqualification of tax relief. It doesn't mean that the bond itself becomes invalid. It's just that it's in relation to the tax treatment, that the previous tax exemption or relief is not continued. So this is in relation to the tax arrangement, and it doesn't necessarily mean that when it comes to the product there is a default. If the tax exemption or relief is revoked, then it will increase the issuance cost, yes. And in case of default, in the issuance paper or the prospectus, there will be arrangements setting out how one can claim back the money. That this will be done in accordance with what is set out in the issuance paper or the prospectus. Mr. Kenneth Lam, I would like to follow up on the question of Mr. Chen Kam-lam. If the bond arrangement or the investment arrangement cannot meet certain conditions, and after it's issued, the tax concessionary treatment is revoked and is retrospective, will it affect the coupon rate? My impression is that the issuer will have to absorb the cost. So the coupon rate will not be affected even the tax relief is revoked, or am I wrong? And that is the undertaking at the time of the issuance. Factors to be considered are market factors. We have not catered for the impact of the loss of the tax qualification. We leave it to the market. Mr. Ho. I can supplement. If the qualification is revoked, the issuers will have to bear extra tax burden. Will it reduce the rate of return for investors? When it comes to the issuance papers we've come across, we found that the coupon rate has been clearly set out. So the risk, such risk will have to be borne by the issuer. From the cases we've come across, and that was the case I've just mentioned. I would like to get some information. Do you have any information or figure about the issuance of Islamic bond on the mainland? Say, for example, CIC or some sovereign fund or mainland institutions, have they invested in any Islamic financial product? We don't have such information on hand. Please try to find them. Yes, Mr. Ari Lee. Paragraph 5. You said that when it comes to Islamic bonds, this is more complex in terms of product structures than their conventional bond counterparts, and they will have to be vetted by the SFC. And so as long as they meet all the disclosure requirements, they can be sold in Hong Kong bond market, and there is no further approval or vetting needed. That is the regulatory regime, as I've said, that the intermediary, if there is an intermediary offering services, then the intermediary is also subject to regulation. So interested Islamic bond issuers only have to meet the requirements of the SFC for them to issue the bonds. Is that right?
Yes. Is my understanding correct? Yes. The present SFO has requirements on disclosures and conduct of intermediaries are applicable to Islamic bonds as in other bonds. So we are not setting out another set of regulations on Islamic bonds. So the amendment bill is really targeted or focuses on treatment under the IRO and SDO so that they can be treated in a fair manner. I think the arrangement is quite reasonable, but I'm worried whether other jurisdictions have the same problem. The Islamic world is not familiar to us. And the bond issuers might be Islamic conglomerates or people from Islam. And if there are disputes, we may have to go back to Islamic jurisdictions to resolve disputes. That's not necessarily the case, Mr. Liu. Okay, Chairman, perhaps I will supplement 2 points. Mr. Leung raised, if there are practices which are not complying with the Sharia law, then what are we going to do? The bond issuer has to resort to the advice of the religion of the Islamic experts to ensure that the products comply with the Islamic law. Now, of course, as the official governing body, we will not be making arrangements for them in that regard. So it's really incumbent on the bond issuer to make sure that the products are meeting with the Islamic Sharia. The second question, if disputes arise. Very often now, in the issuing document, the law system applicable will be clearly spelled out. In the market, stipulations have been made on the applicable law. Say UK law, and we hope that investors can look in detail the document on the laws which are applicable to the bond. This is not a sort of unique question in bond issuing, Islamic bond issuing in other places. I mean, the stipulation is there. The bond issuer might not necessarily be Islamic banking institution. If other institutions are familiar with Islamic laws and meet with our present requirements, they can issue bonds. Mr. Kenneth Leung, I would like to supplement a bit. In the Hong Kong market, there is an offering of Islamic finance products already, but they are not massive in scale at the present. I think the vetting process should be similar to other financial products. I have this question about record keeping. You said you've taken on board views of the industry. So how long are you requiring the bond issuer to keep the records? When can they cancel or delete them? Yes. In our document to the Legis is on page 9. There is this footnote, paragraph 13. We said here that they will seek to require relevant documents for the purpose of the ILO or to be kept until the expiry of 3 years after the end of the ABS term, or the expiry of 7 years after the relevant transaction, whichever is the later. For the purpose of the SDO, the bill will require relevant documents to be kept until the expiry of 1 year after the end of the ABS term. Clear, right? All right. Any other questions from members? And we would scrutinize the amendment bill. And Mr. Sin Chung Kai and Mr. Kenneth Leung raised that we invite members of the public to come and express their views. Let's see what time slot should be available. Maybe after the Lunar New Year, around mid-March, perhaps. Initially, we proposed that the 18th of March, morning 8:30 to 10:30 a.m. 18th of March. Well, 8:30 a.m. to 9 a.m. are similar. The clerk will remind members, or perhaps we can start at 9 a.m. Maybe 8:30 works better, because if you schedule the meeting at 9 a.m., we might run into traffic congestion. All right, let's make it fix it at 9 a.m. The 18th of March. Is it a Monday? Yes, it is a Monday. Quorum is 3. Well, if the members of the public are going to be here, then it won't look nice on us if we just have 3 people. So please attend us if you can. 18th of March, we will use conference room 3. Okay, we will look at it again, and we will notify you if there are many deputations. We might have to use a bigger room. Okay, in between, we will not convene any meetings. So let's hear what the public have to say, and then see if we want to tackle the other issues. And then after that, we will look at the bill clause by clause. Well, so much for the meeting today. Thank you very much.